not gone into their settings and to have checked a box to ensure that their information was had additional privacy protections, those one step and one omission together meant that there would be meaningful consent for their friends to share, for my friend to share my information with any app developer, regardless of purpose. That seems to me to be contrary to any notion of meaningful consent. What do you think about that?
Well, I think that's the basis of our fine. So we found that there wasn't consent, there wasn't meaningful information, there wasn't meaningful notice, and terms of service can't trump the law.
Well, you said it's a sort of a privacy law 101. Facebook is worth billions and billions of dollars and can surely hire a lawyer. A lawyer wasn't here before us today, but why do you think it is that they're still challenging a ruling when the basic premise of meaningful consent is so very obvious to any lawyer who's ever practiced privacy law?
Because the profiling and the use of personal information, complying with meaningful consent and notice is a tension with their business model. But I think there's a way to resolve this, but regulators need to enforce the law. I need to do my job, and that's what I'm doing here. And Facebook has the right of appeal, but I think they shouldn't misrepresent our findings and the basis of our monetary penalty.
But and from a legislator's point of view, when one is frustrated with the lack of accountability, and certainly what seems to me to be Facebook officials coming to the table and apologizing only after they have been found out to have made a series of mistakes. It's frustrating and bizarre, I think, also, that they continue to compound those mistakes and to say, we're sorry, but oh, by the way, we did nothing wrong. It's strange. So with respect to penalties, so in the Canadian context, our Federal Privacy Commissioner does not have the power to make orders, does not have the power to levy fines. I've actually introduced a bill in Parliament to address that, but you have now powers under the GDPR to levy significant fines. Facebook, I was on a panel recently with the head of public policy for Facebook Canada who said, well, naming and shaming works just fine, and the Ombuds role has served us well. And your view of the Ombuds role versus having significant powers, do you think companies like Facebook are responsive to naming and shaming, or do you think the power to levy fines is of critical importance?
I think you need the whole package. So you have to have the ability to issue orders, maybe a stop processing order, telling a company they can no longer process personal information for a certain purpose and in a certain way. That's pretty powerful. But having the fines available is a way, I think, to focus attention at the board level of an organization and really build good data governance.
Thank you. Joe Stevens.
I just want to go back to a question that I asked you when you came to see us on the 6th of November, if I could. It was about illegal data sharing between Aaron Banks's Eldon Insurance and the Leave.eu campaign, when in September 2015, Eldon Insurance sent over 300,000 emails to newsletters, Leave.eu newsletters, to Eldon Insurance customers. Now, you issued an information notice to Eldon Insurance in April 2018, and Eldon Insurance told you that they themselves had reported that breach to you. And I asked you, I think in November, when they reported that breach. Can you tell us whether or not you have found out from them when they reported that breach, and have you had any proof of that, please?
Eldon Insurance stated in response to our information notice, as you said, that they reported that breach to us when information was shared between both Leaving EU and Eldon Insurance, and we found no evidence of their report of such a breach. So, and you know that we've issued fines under the PECR regulation against Eldon Insurance, and we continue to investigate data protection issues, and we have announced an audit of Eldon Insurance as well.
And they haven't subsequently provided any proof to you to back up their claim that they...
They have not.
Right. Thank you very much.
Thank you. Bob Surratt.
Yeah, thanks again, Ms. Denham, for speaking to a committee the second time, first time on this side of the Atlantic. I guess just one question I have for you. We're tasked with making laws to really get a handle on Facebook and the social media platforms, etc. And I guess I would just look to your advice. What would you do if you were in our place? If you, and I know it's difficult in your maybe your role to say so, but as much as you can say, where would you start with these guys, and how would you best? I think from my perspective, the democracy's at risk is my most important in terms of my view, my concern. How would you best combat that, and what kind of laws would you make? This could be a 2,000-hour conversation, but I'm trying to say it in as brief as an answer as you can give. Where would you start?
Well, one of the reasons that we launched the investigation in 2017 was to look at the whole political campaigning ecosystem. Mm-hmm. And who are the players in that system, how is data collected and used, and what are the responsibilities of each of those various actors. So political parties are part of this. Political parties have a lot of data. They purchase data, perhaps from data brokers. They collect it in various ways. So we need to look at political parties as part of this as well and make sure that they're able to use new digital campaigning techniques to engage voters, and at the same time, obviously, comply with the law and be transparent and give people control about how they use information. So this isn't just about social media companies. Right. They're a large part of digital campaigning now, and the spend that political parties and campaigns put towards digital campaigning is growing. But before the train leaves the station and even more intrusive techniques are used in our democratic processes, we have to get a handle on this. So electoral laws, I think, need to be strengthened and brought into the digital age. So election financing, all the transparency and imprints in advertising on platforms. This isn't a simple answer, but we need to look at all of the existing regulations, make sure they're up to date and fit for purpose, but also I think a code of practice for political parties and campaigns, because they're at the center of using these services. And that's one of the main recommendations that our office has made in this investigation, is for a statutory code of conduct for the use of data in political campaigns. That's important, and that might be something that's, as we develop this code, that might be of interest to other jurisdictions.
So the part B to that question then, because we've seen political parties, and we had political parties just appear at our committee in Canada to answer questions, but I think for the most part, political parties follow the rules. It's in their best interest to do so and follow the framework as best they can. Again, it's in their best interest to do so. My main concern, although that is part of it, my main concern is the foreign actors and the people that show up with a Facebook account that's started 1 week and is actively campaigning against members of Parliament sitting around this room here for whatever reason. How do we best get a handle on that? The outside, the official establishment, how do we get to those bad actors?
In terms of that, the context of, I guess, of different actors coming into the political space and just not the main parties, I think the proposals we've seen around better registration systems for how political adverts are to be organised online, and then the transparency which follows from that, so you can actually see who's targeted that advert and who's paid for it. I think the challenge is to make that work in practice, and it's certainly something we know the Electoral Commission are taking a strong interest in the UK. We've seen Facebook have rolled out this initial programme in the UK. We've certainly seen some evidence, but it's been circumvented already in some circumstances. So I think we've got to learn as well how to make this work in practice. So it's good to see some proposals coming forward about making this work, but particularly for those actors who perhaps may have an interest in not being transparent about who they are in terms of using the advertising systems on social media platforms. We've really got to focus on some quite strong governance, which really gets people to engage with a process of identifying who they are, so that that transparency works in practice, so that you can follow the money, see the ads. So I think it's a good principle, and we're supportive of it, and we made a recommendation around that area that it should go forward in our report in July. I think we've got to learn from the practice and see how it's working. It's obviously been rolled out in other countries as well, so we look forward to seeing how that works.
Thank you.
Thank you. Charles Watling.
Yes, thank you, Chair. I'd like to move on to the regulation. We touched on it earlier. You said in your excellent response to us, Ms Denham, that you acknowledged that without a very substantial injection of resources and headcount, that it's unlikely that any regulator would be able to directly handle the volume of individual complaints and so on. I'd just like to ask you, do you mean by that, whatever regulations we might like to put in place, that it's almost unenforceable?
Not at all. So my response around internet harms was not necessarily just in the political context. It was about regulating content and conduct online. And my point was that if you set up a regulator to take complaints about takedown requests where somebody saw offensive material online and wanted it taken down, and went to a regulator with every single complaint, then you would have a regulator dealing with millions of complaints.
Yeah.
So rather than that system, I think what's an opportunity to think about is regulating the effectiveness of processes that have to be put in place for things like taking down or responding to complaints from individuals. So the regulator is saying, are all of the processes effective for meeting the public goals and the objectives that are set out by Parliament? So you come up with a standard, and the regulator has to go into Facebook, Twitter, Snap, Google, and say, show me how effective you are, and be transparent about the numbers of takedowns, the context of the material, because we're talking about something that could have potentially millions and millions of complaints.
So what you're saying is you're relying on the companies themselves to do that work.
But you have a regulator as a backstop that's ensuring that they are meeting standards that are set in law. Right. And that's what we don't have right now. The gap in internet harms is we don't have anybody who is regulating content and conduct online. We're regulating the use of personal data. We're not looking deeply into content.
So that's what you would recommend that we do, and that's what you'd recommend we do on a global basis.
I think that's where the public concern is. The public is really concerned about what happens online and the kind of harms online, and they expect their parliaments to regulate, to protect them from those harms.
Thank you.
Thank you very much. Soon Su Ling. Okay, fine. Evan Tom.
Ms. Denham, good afternoon. Thank you very much for being here, and also for your note which you've sent to the committee before today. I have a couple of questions that arise from what you've said here. And one of the points you made at, I'm not sure which page this is on, but in the, I think, second full page of the note, you say that a coordinated approach needs to be taken to internet harms. By that, I take it you mean that not only do we need regulation and legislation like you spoke about a short while ago, but also a range of other measures such as media literacy, improving standards of journalism, for instance, making sure that the schools teach our children the right approach to being more discerning on the online and so on. Would I be correct?
I think addressing the kind of harms that the public is concerned about everything from misinformation to disinformation to opaque advertising in the political arena to kids spending too much time online.
Mm-hmm.
All of these issues, data privacy as well. It's complicated to say how are we going to address this.
Yes.
But I think digital literacy and digital media is really, really important, and that makes us all a little bit more diligent in how we read things online, understand them. But we also need transparency. We need more regulation. There's so many different aspects to this.
Yes.
And when you look at the political context, which has been the focus of our investigation, we have some very specific recommendations.
I understand. So what you're saying is that there's no single silver bullet, but there's got to be a suite of measures to tackle this problem.
You said
Right.
it. You said it very well, and I think there are many actors in this space, from companies to citizens to the education system to the social media companies to Parliament.
Right. Now, on discussion of legislation, you mentioned in your report that there are still a number of internet harms which do not appear to be fully addressed by existing law and regulation. And you go on to cite the fact that online harm, which may be currently legal, online harmful conduct which may be legal, needs to be dealt with. Can you elaborate on that?
So obviously, countries have defined what is illegal online, and the issue there is how is that enforced? How quickly do social media companies and online platform remove and deal with illegal content? But the gap is actually in content which is legal but may be offensive
Yes.
to certain individuals, kids. That's a good example, and that's where I think the public is looking for legislators to find the right regulatory approach that deals with the online harm, but also protects freedom of expression, protects innovation, and balances those processes.
Yes. So to protect, say, children from, well, not just children, but the general public from content that could be seditious, for example, or that could be insightful of hatred conduct, would be something that you would look at and
I think
seek
so.
regulation
Yes.
to protect general public against. Would that be right?
That's correct. And although it's complicated and it's complex to come up with the rules that are going to balance all of these interests, it feels, and our research shows, that that's what the public expects parliaments and legislators to do.
So the sense is that some kind of legislation needs to be enacted to deal with those online harms, define what those parameters might be, and again, to borrow your language, you say here also that online non-criminal harms could be as significant as criminal harms because of the scale of the potential activities. And by that, I think you mean the proliferation of material on the internet and quick speed and spread of such material on the internet. Would that be right?
That's exactly right, and we're especially concerned when it comes to children and vulnerable adults.
Right.
Did you want to add to that?
Just to add really about preparing to think about legislating this area, I think it's probably the biggest gap because it's the most complex area because it's the intersection with freedom of expression, and the public have a wide spectrum of views about what they might find upsetting or information they think should be removed. And I think we've got to learn how to have quite deep dialogue with the public. We've got to come up with ways of research, probably concepts like citizens' juries, to really come up with some sophisticated ways to balance these issues to get the decisions right. And I think the issues about harms which may build over time, may have an impact on people's mental health, etc.
Yes.
Those issues we've got to factor in the longer term effects of various internet harms. We've got to learn and have all of the evidence and research to back up that approach
Yes.
to take.
So those objectives has got to be balanced with the speed at which you can address the harms being spread. So one needs, I would imagine, strong levers, quick levers in order to stop and stem the tide of the spread. You would also need to be very clear as to what kind of information society to society may differ. And so I think each parliament has to be looking at it from the perspective of what society needs to be protected against.
I think certainly from the perspective of the public, when they see something concerning, upsetting, they expect something to happen fairly quickly. So you're right, I think we've got to learn how the levers can work in practice from the companies responding, and also what the checks are from the regulator to look at the overall systems they're using. If those need to be adjusted, if the criteria they're using are not right, that overall system approach has to be adjusted quickly to reflect concerns as well.
Right. Thank you.
Thank you. Julian Knight.
Thank you, Chair. Mr. Dunn, you've been, during the course of inquiry, you've been very helpful to this committee. You've been very open both in public and private. First of all, I'd like to thank your organisation for the way in which it's interacted with the committee. But I do have just a few questions I really want to put to you. I mean, a £500,000 fine for Facebook. I mean, that's probably its sandwich bill for a week. This is almost the definition of a drop in the ocean. What more can you do? Does it actually need to be something that's really fundamental, that really hits them very, very hard indeed in the pocket? The sorts of super fine that we've seen from the EU in the past over American institutions. Do you feel somehow frustrated about the level of fines you're able to issue? What are your thoughts in terms of that fact about the fines that you're issuing?
The £500,000 fine that we issued against Facebook was the maximum fine available to us in the previous regime. So because the contraventions happened before May 25th, 2018, £500,000 was the maximum. And I've been clear that had the maximum fines been available under the GDPR available to us now, we would have issued a much more significant fine to Facebook.
So would you have issued the maximum fine?
A much more significant fine.
Right.
But it's a bit hypothetical because that wasn't available to us. So we now have up to 4% of global turnover, as do the other EU data protection regulators, and that's a significant fine for a company, and it would have an impact on the bottom line of that company. But I also think that our findings and our fine that we have issued is important because we have found their business practices and and the way applications interact with data on the platform to have contravened data protection law, and that's a big statement and a big finding.
Yeah. So are you looking at Facebook right now in terms of potential contraventions after the new regime came in?
We are, and as you know, with the GDPR, the new legal arrangements are that it's the Irish Data Protection Commissioner that is responsible as the lead authority for Facebook, because Facebook Europe is based in Ireland. So we are working with our Irish colleagues. We have referred matters of an ongoing nature, concerns that we have in Facebook right now. We've referred those on to our Irish colleagues, and as a competent authority, we are available to help them with that.
Given Ireland's record with firms locating there in order basically to avoid tax, do you think they're going to be as firm as they ought to be in terms of pursuing Facebook and ensuring that these potentially current transgressions are properly punished in a way that the public actually has confidence in?
There are several investigations ongoing under the lead of the Irish Data Protection Commissioner, who I have great confidence in, as well as our other regulators in the EU. So we have joined together in a social media working group because there are so many issues when it comes to some of these tech giants.
Yeah. It doesn't look to me, though, as if, frankly, with this issue of Ireland having the competency on this, it doesn't look to me, frankly, as if the sort of promise that the new regime has in terms of really punishing these firms when they do transgress in this way. It doesn't seem to me, frankly, at this point, as if it doesn't have a great deal of teeth because of that issue of Ireland being in charge of the process, rather than, for example, you going in there and saying, hang on a minute, you're trading in the UK, and therefore you should be facing maximum fines if you are transgressing.
I mean, certainly we've observed closely how the Irish Commissioner's Office has also increased its resources over the last few years to prepare for GDPR. They've over doubled the staff, they're hiring technologists, they're getting ready for this challenge. I think the other thing, just to build on what the Commissioner talked about, if the Irish Data Protection Authority have a case which affects data subjects, people across Europe, then they have to probably have to prepare a draft decision in that situation. It could then be essentially called into the European system as part of the mechanisms under GDPR. And an overall decision, if the other European data protection authorities, for example, don't agree with that draft decision put forward by the Irish in that instance. So there can be a European-wide decision as part of the mechanism. So there's some balances and checks to make sure it's addressed the concerns of the Europeans.
Can you recommend, though, that they have to find the maximum amount?
That would be part of the discussion. Will be has the GDPR been applied correctly in that situation?
Thank you, Chair. Thank you.
You have mentioned that regulation should be a backstop to regulate content and conduct. Would you agree then that there is a need for a framework to bind tech companies, regulators to collectively address disinformation and online falsehoods?
A collective action between regulators and companies?
A framework to bind tech companies and regulators together.
So I believe that the time for self-regulation in this context is over. And my recommendation to the committee for consideration is that because of the public concern of these internet harms around content and conduct online, that Parliament needs to define the outcomes. There needs to be a set of standards that are agreed, and a regulator has to be equipped with the right powers to be able to review the activities of the companies. The complexities of the different platforms is something to take into account. So Snap is different and has different operating processes to Facebook, to Google. That's why I think the platforms have to have some overall standards they have to comply with, but they have to be judged in the context of who they're serving. So a platform that's operating and serving kids, for example, there would be some different requirements. But just to be clear, I'm not advocating for a self-regulatory model. I'm advocating for a strong regulatory backdrop to a set of standards.
Thank you.
Thank you. Pritan Singh.
Good afternoon. The realm of fake news and disinformation is not just the domain of opaque social media companies. In this social media age marked by technological innovation, it can be argued that opaque governments precipitate the formation of a vacuum which is then filled by or abused by peddlers of disinformation and fake news. Given your experience, what advice would you give governments in general and opaque governments in particular around the world that seek to move in the direction of open government? And closely associated, I might as well put both questions together. How does open government better inoculate a citizenry against disinformation and fake news?
That's a question we're quite happy to answer as well, because the other piece of legislation we're responsible for as a regulator is the Freedom of Information Act in the UK. And I think government setting the example of putting as much factual information into the public domain to support an informed debate, so that provides a rich seam of information which can support debate, and government showing the way by being open and proactively responding to freedom of information requests that citizens may make, and that also being part of a fact-checking process. That's probably another part of the jigsaw which I think can set an important standard. I think, as we've discussed already today, it's another lever which can help improve the environment. And I think if government is legislating in this area, a good way for government to set the standard is showing how it's being open itself. I also think that means embracing new technologies about open data, very much explaining how data can be used to understand the workings of government and making that available to civil society, etc. So I think certainly it can have a role to play in that wider debate, but it's one part of the jigsaw.
You spoke about fact-checking. I think it's one of the recommendations actually that our select committee in Singapore actually looked into. Of course, it's not so simple because there are other questions about who finances it, who funds it, and questions of that nature. If you have the government funding it, then of course the question is there an obvious conflict of interest there? What advice would you give for countries which are considering fact-checking platforms, particularly small countries like Singapore, where the media landscape or media companies may not have I wouldn't say deep pockets, because some of our media companies do have deep pockets, but obviously again a conflicted party driving that fact-checking process, because there are contradictions.
I think certainly you're right that it's a balance, because equally you don't want to have a ministry of truth and an overarching body which decides all factual bases that people might seek to complain about. I think certainly having a strong regime for the regulation of national statistics, which we have in the UK, is a good basis to start at some core areas where data is particularly quoted as a central area of national debate. Also, I think a strong and vigorous civil society of fact-checking groups, as well as starting, I guess, still to pioneer some ways of how to do that, how to use large data sets as well, because fact-checking can often be complicated with big claims as well. And I guess the UK, like a lot of other countries, is finding its way. But I think at the core has always been a bedrock, I think, of particularly official statistics, and a high degree of confidence in that area is an area the UK has led strongly on in that area.
Thank you. Thank you very much.
Thank you, Nathan.
Yeah, just really quick, you had mentioned the need to, or the public's concern is additional regulation perhaps of content. Now, I'd asked Facebook because they supported an act dealing with tackling content and perhaps even legal liability for Facebook if they don't take down content in relation to child exploitation. It seems to me it's a short step to then imposing legal liability for failure to take down hate speech and other obviously and horrible illegal content. That wouldn't be yourself regulating that. That would be some agile judicial oversight of some sort in coordination with whether it be the companies themselves or some other regulator. But you spoke to regulating effectiveness of processes, and you've spoken to transparency, but I haven't heard today anything about algorithmic transparency and auditing algorithms. And I raise this because Richard Allen said something at the end, which I wish we'd explored a little bit more, which is he said where content is right up against the line, and we've deemed it not hateful, so we're not taking it down. In fact, their algorithm has a perverse effect, whereas because it is divisive, because it is designed to get a reaction, their algorithm actually increases traffic for that content, and they are looking at maybe not rewarding this content that is pushing up against the line of hate. That seems obvious for a company to do that if they cared about the public interest. Would the ability to audit algorithms reside in your office? Is that the appropriate place? And speak to the importance of algorithmic transparency and auditing algorithms in a human rights context.
Right. Under the GDPR, there's enhanced requirements for explainability in algorithms in the context of personal data. So if a company or an organization is making a decision that's basically by machines, it has to be explainable, it's challengeable. And another part of the work that we do is we are going to be auditing algorithms for issues of fairness, data protection, bias, all of these issues. So we're going to be in the space of looking at algorithms and looking at transparency. But you're talking now about algorithms used to deliver content. And that's associated with us, but it's not right in our space.
Right.
The challenge is, I think the challenge for all of us is that data protection is horizontal. It runs across digital advertising, digital campaigning. The use of personal data it's part of all of this. But we're not an expert content regulator, but nobody is. So it's whether or not a country, a jurisdiction thinks about sharing the load between existing regulators and finding some kind of a collaboration, or creating another regulator, but you have to be careful that it's not actually crowding out the existing space, because that creates confusion for individuals and confusion for companies.
Right, because it seems to me we have this traditional regulation of content in relation to editors, and we hold editors accountable. And as editors are replaced by algorithms, for some reason we've failed to hold the algorithms accountable and to hold the companies that are making billions of dollars in profit from these algorithms, in part at least, Thanks very much.
Thank you. Bob Zimmer.
Actually, I'm going to pass my time over to Mr. Lucas. I think he can answer it better.
Okay.
Yeah, sorry, we know we're not reading each other's minds here.
Just a couple of brief follow-up questions, actually, just on GSR, again, I'm afraid. Firstly, I think you said in your evidence that within Facebook, they were first aware of this in 2014. Is that correct?
I would have to go back and look at the report. Are you...
Because the evidence we've had is that some of the evidence is that in the awareness of within Facebook was because of a news report in December of 2015. That's why I'm asking the question. Are you aware of them having any awareness before 2015?
I would have to write to you, Mr. Lucas.
That's
fine. I don't
fine.
have the report in front of me.
That's fine. And also connected with that, you referred to a number of senior managers, I think was the phrase or the wording that was used. Can you name them?
We can write to you with those names. I think what we've written so far is we've described the types of positions and titles.
Yeah. But even those, we're discovering that the Facebook management structure is somewhat Delphic. And I think the best way of us being clear about change of responsibility is to have the names. So if you could write with the names, I'd be very grateful.
I will write.
Thank you.
Thank you. If I could just close with a few questions, I don't think there's any other... oh, sorry, Charlie, yes, you go first.
I just want to follow up on my colleague's question about algorithms, and I ask you because you come from a Canadian context, and we have no digital committee in Parliament. The Ethics Committee, our usual job is smut and corruption, and dodgy lobbying meetings and loopholes, and that's something I understand. I got 52% in grade 10 math. I don't know what an algorithm is, and yet I'm being asked now more and more to say we have to start looking at the ethics of algorithms in terms of public policy. So as much as we look to our regulators to try and understand this, as parliamentarians, we're setting public policy based on how governments will deliver services, how all manner of things will be. I just would like to follow up on my colleague, a suggestion or recommendation where we need to go in terms of starting to put the issue of ethical accountability for algorithms as a public policy issue that needs to be looked at and we need to keep an eye on, whether it's a standing committee or whether it's a one-off study. What would you recommend?
I think it's a critically important area of study for legislators. In the UK, committees, the House of Lords, Commons committees have been examining the impact of algorithms and AI on society across all sectors. In the public sector, in the private sector, the impact of AI on future employment, on jobs, self-driving cars, robotics. These are really critically important areas. So a standing committee, various studies, absolutely, in Canada, because you have the focus on digital innovation in AI, the public policy that goes along with that and the digital ethics are critically important.
Yes, Rebecca Power.
Do you think that a committee like this, going forward, could be valuable in informing how we are actually going to go about regulation on a worldwide scale? Because it's quite clear to me, talking to all these different countries who are doing a great deal of work individually, that this is much more than an individual country issue and that we do need to align.
I'm really pleased to speak to this committee. We've got 9 jurisdictions here representing 450 million people, looking at issues related to internet harms and electoral interference. These are widespread concerns, issues of widespread concern to your citizens. And I mean, ideally, there would be some kind of international instrument or an international agreement with a set of principles that your democracies could agree to. That's going to be some time away, I suspect, because domestically you have different constitutions, different cultures, different laws. But I think that all of you share some things in common, and we do have these big internet companies that are working in this space and are globally delivering services. So the answer is yes. I think working together is very positive for your citizens. And when one jurisdiction goes out with a new solution, we have France coming forward with their judicial decisions around taking down disinformation. We have Germany's approach. The UK has been very strong in examining these issues and bringing regulators together. The European Commission has the voluntary code. So there's been a lot of initiatives, but getting the jurisdictions together to look at the best approach is very positive.
Okay. Thank you. Elizabeth, if I could just ask a few questions in closing this session. When you gave evidence to the committee earlier this month, we talked a little bit about your discovery of Russian IP addresses remotely accessing the data collected from the My Digital Life app, wasn't it? Right. The precursor to the Cambridge Analytica data gathering app. Are you able to tell us any more about those investigations looking at the Russian IP addresses and where they may have come from?
So those IP addresses that resolved to Russia, we have reported and been working with the National Crime Agency on that issue, and it's not one for us to chase down what's going to happen and what has happened at the other end of that, but we continue to work with law enforcement on that. I have no further update than our private session earlier.
Yeah. So would you expect that investigation to be concluded when the NCA completes its investigation and makes takes whatever action it needs to take?
I expect. What I don't know is whether the result of that investigation is going to be shared with parliamentarians, some parliamentarians. You probably know that process better than I do.
If the National Crime Agency decide there hasn't been criminal activity and decide not to take any further action, would you be able to report in more detail back to the House once once the NCA's investigation is completed?
I'll get back to you on that.
Okay.
I need to check with the NCA and the NCSC.
Just following up on Ian Lucas's question about senior executives at Facebook that were aware of the Cambridge Analytica data breach. I appreciate you've got to write to us with names, but from your investigations, do you feel that Facebook has a sort of process in place to notify the senior team of issues like this? Is there a clear reporting path? Are there clearly executives to whom
that would be the case?
I think we would just expect the situation to have improved since some of those historical events that you're looking at as well. So the requirement under the GDPR is for organisations to appoint a data protection officer when they have a risky profile in terms of the types of data processing they do. And that has to report to board level in organisations. So there are some strong drivers there, particularly looking ahead, how internet companies should have the right sort of governance in place for these things to be escalated. So I think it's important to look to the future about what should be done as well.
So, but do you feel, I think from what you said, you can imply from that you don't feel that in 2014, 2015, they necessarily had those structures in place?
I know it has improved. I know it has improved since then.
Yeah. The
company's changed significantly since 2013, 2014, and it's certainly changed since 2008, 2009.
But would it be fair to say that from your investigations, you don't believe that there's a clear reporting structure to board level for data breach issues, data privacy issues?
There is now, and it's legally required, that there is a straight reporting structure all the way to the board level.
But you don't. But you don't think it was then? I
don't think it was in place in 2013, 2014.
But do you think that's extraordinary, given that it was in late 2011 that the Federal Trade Commission ruled against Facebook for a lot of the reasons you set out earlier on, that they weren't protecting users' data and that apps were able to gain as much access to user data as they liked, but seemingly without any restraint. And given that complaint had already been made in 2011 and the company was required by the FTC to put those policies in place, I mean, it does seem quite shocking that potentially 3 years later they still hadn't put those systems in place.
I think that Facebook continues to mature as a company, and I think the pressure that sessions like this and the committee's work and investigations by the FTC, by our office, by Europe, by Ireland, we need to keep that pressure up. And as I said, I'm very disappointed that Facebook, being such an innovative company, couldn't have put more focus, attention, resources into protecting people's data.
Yeah. It just doesn't seem that they took much notice of the FTC's report.
The FTC, as you know, the FTC is having another look at its consent decree, and it'll take some time, but it will be reporting out as well.
Yeah. You said earlier on when talking about users should give informed consent to the use of their data, and you said that with regards to the data gathered by Alexander Kogan for Cambridge Analytica, that this was, your words were just one example. How many examples have you seen of breaches in user data policy?
I mean, we very much obviously focused on that one area in our investigation. Obviously, we mentioned earlier that we heard the news that Facebook had suspended the 200 apps as well. So we're aware it's a widespread problem. We really tried to focus in and narrow in on the areas where we could really make a difference, which is why we focused on Facebook at a platform level to ultimately reach that finding when we've issued the adjudication, which has led to the fine.
Because, but are there any other examples you've investigated?
As the Commissioner mentioned earlier, we've still got ongoing interest in other apps connected to the Psychometric Centre in Cambridge, and that's an ongoing area of interest.
And these are apps that are not currently known about? It's not the public domain that this is being investigated?
That's right. But in terms of looking at Facebook, we've looked at Facebook in different contexts. We intervened on the merger between WhatsApp and Facebook, because the reason for that merger was increased sharing of data. So we actually worked with WhatsApp and Facebook and have an undertaking by WhatsApp that they will not share information with Facebook until they can show that it complies, their plans comply with the GDPR. So we've looked at Facebook in other contexts, but I think your question is really focused on apps.
Because I think one of the concerns we have, and this came up in the questioning earlier, and I think comes out of the papers from 643 that the committee's been given, as to actually whether the problem of widespread access to user data and user friend data without the knowledge of the users was so commonplace that it might not necessarily appear to be a problem to Facebook.
That could be the case, and we're interested in the 643 evidence. We knew about the company, and they were unable to share that information with our office because of the seal by the court. So I am interested, if we are legally able to look at that data, we'll look at that, and that might be important to the litigation that we're going to have with Facebook, because the hearing before the tribunal, there is a potential of new evidence to be submitted in the context of that hearing if it is relevant.
So you believe that the unsealing of that evidence could be important to your current investigation into Facebook?
We don't know what the evidence says,
no.
But it could be, because it could go to decisions that were made in the 2013, 2014, but we haven't seen the records.
But you said that you had approached 643 yourself to ask whether you could have access to that.
We had a conversation with 643. We talked to their lawyers, but at the time, because of the sealing of the records, they were unable to share the evidence in the email with our office, and this was some months ago.
Yeah. Well, I certainly think that the evidence contained within those sealed documents will be of considerable interest to the Information Commissioner's Office, as it is to us as well. If I could just ask finally, just on Cambridge Analytica, do you believe do you believe that the database collected by Cambridge Analytica, the tools that they acquired, do you believe they're being used by other companies today? Do you believe that they're effectively trading under a different name?
We are actively monitoring the former directors or the directors of the company and any spin-off companies that come out of it. So we are actively monitoring that. We have the ability to follow the data. We're still crunching through 700 terabytes of data, so we are discovering more about Cambridge Analytica as the time goes by. And as you know, we're in court on a criminal matter with Cambridge Analytica in January, so we continue to pursue that.
Yeah. Has the ICO looked into the company Emerdata, which the committee have taken interest in before?
Yes, that's an active line of inquiry.
Okay. In terms of whether Emerdata is being used as the vehicle for Cambridge Analytica? Yeah.
Yes.
Thank you. I think that concludes the questions we have for the session. Once again, Elizabeth Denham and Steve Wood, thank you very much for joining us today.
Thank you.
Thank you. So members, we now have a final witness who will take the stand now. So that will be Ashkan Soltani, the former US Chief Technology Officer, will now give a short evidence session. Thank you. We'll start this final part of our session this afternoon. Ashkan, perhaps you could, I know that you were, I believe, monitoring the session we had this morning with Facebook. Obviously, the work of the FTC in the FTC report in 2011 was something we asked a number of questions about. And perhaps you could just share with the committee your thoughts and insights on the evidence session you heard this morning, and whether Facebook's interpretation of the FTC's ruling and how it's tried to comply with it, how that sits with your own views on this matter.
Absolutely. Thank you. And thank you for having me. Just a quick background. I was a primary technologist at the Federal Trade Commission that worked on the Facebook investigation in 2011, 2010 and 2011, and I was later the chief technologist at the FTC in 2014. I also worked briefly at the last White House, the Obama White House, Office of Science and Technology Policy, and most recently helped write the California consumer privacy law that just passed in June. My opinions here are solely my own, and given the nature of the FTC investigation, they'll be based on only publicly available information. I also want to apologize for my attire. I wasn't planning to testify today, so I didn't bring any clothes. I'm just borrowing a
You should have come
blazer.
to our live music hearings. That was a different order.
I had a hoodie, but I fortunately got a blazer. Mostly, I just want to make 3 quick comments based on the comments from this morning related to what I've observed in my work, both as an independent researcher and from what's public in the FTC settlement. So at the very beginning of the hearing, around 11 minutes in, Mr. Allen corrected one of the comments from you all about specifically that apps in version 1 of the API didn't have unfiltered access to personal information. And in fact, this is false. In the 2011 FTC settlement, the FTC alleged that if a user had an app installed, it had access to nearly all of the user's profile information, even if that information was set to private, right? So, so there's some, I think, sleight of hand with regards to V1, but this was kind of early V1, and this was only, I believe, addressed after the settlement. Additionally, In the same complaint, the FTC found that Facebook misrepresented their claims regarding their app oversight program. Specifically, Facebook's Verified Apps program, which was a detailed review designed to offer extra assurances to help users identify applications they can trust. The FTC found that that review was actually non-existent, and the company was not doing anything to oversee those apps. And again, that's in the complaint. Additionally, there were some statements made that apps would only have access to information if a user installed and consented to that access. I hope the New York Times in their investigation and verification of the whitelisted apps program, and I have some tweets to this regard that show the screenshots of this access. Specifically, apps were able to circumvent users' privacy settings or platform settings and access friends' information as well as users' information, such as birthday, political affiliation, even when the user disabled the platform, right? So these were the pre-installed apps. Additionally, the Facebook, through a program called Instant Personalization, some apps such as Yelp and Rotten Tomatoes would automatically get access to users' personal information even without a user installing it. So simply by being a Facebook user and visiting the Yelp website, Facebook would transmit to Yelp your hometown, your location, your preferences, etc. So those are some discrepancies. I think the timelines vary, but this, in my opinion, was V1 if they're considering the changes in 2014 as V2. In short, I found that time and time again, Facebook allows developers to access personal information of users and their friends in contrast to the privacy settings and their policy statements. This architecture means that if a bad actor gets a hold of these tokens, such as in the case of Pinterest, there's very little a user can do to prevent their information from being accessed. Facebook prioritizes these developers over their users. And I think it was best laid out in Mr. Allen's win-win-win comments that the platform enables things we're not going to do and they're going to do, right? Facebook gets more engagement from the platform. Facebook users do things that Facebook doesn't normally provide, and developers get access to a large consumer base, right? Another way to describe this is Facebook pays app developers to build apps for them using personal information of their users, right? So if you think of if I'm a company and I want to have an app like Farmville or a third-party BlackBerry client written for me, I would have to pay hundreds of thousands of dollars in development time to have that app built. But Facebook says instead, developers, please come and spend your engineering hours and time in exchange for access to user data. And I think that kind of summarizes the core issue. Additionally, from my experience, I don't think Facebook is able to govern itself in this area. From my kind of observations of public data as well as my conversations with multiple stakeholders inside the company, my understanding is that senior leadership simply does not prioritize these issues seriously, and they'll continue to do the bare minimum necessary to pass through the compliance regimes, but will absolutely continue to make these mistakes as their priority is monetization of user data. Thank you for your time and for having me here.
Right. Thank you very much for that statement. So you, from what you said, it sounds pretty clear that what Facebook said to the committee, what Richard Allen said to the committee was not true, that users had no real control at this time over how their data was being used, and certainly, and even when they tried to enable their privacy settings to protect their data, developers were able to get around that without the user knowing.
Right.
Yeah.
And not even get around that. Developers just had access to it.
Yeah.
Right.
And from what you said, this is effectively a commercial decision by Facebook in its doing a deal with the developers in order to encourage them to build on the platform.
Correct.
Yeah. And actually, we want to bring Charlie Angus. You want to come in?
Well, thank you for this. I guess my concern is, because you said you're worried about their ability to self-police regarding these mistakes. This is a company that we've been told made $18 billion in the first quarter this year. This is a very, very focused, driven corporation. The fact that they are ignoring their obligations cannot be, to me, seen as mistakes anymore. The fact that their senior representatives spoke to a parliamentary committee, which I do believe, the way we have it in Canada, when you speak to a committee, you're testifying as under oath.
Correct.
To misrepresent basic facts, to me, is a contempt of our legal parliamentary system, but it's also a question of, if we cannot trust them to follow the law, we have bigger issues. And I want to ask you, from your regulatory position, that we see in Canada a real unwillingness of Facebook to show up to talk to regulators, but an incredible willingness to go behind the scenes, to lobby, to hang out with ministers, to do all manner of favors to get a free pass on legislation. In your experience in the United States, it seems that Facebook spends an enormous amount of money lobbying legislators so that they don't actually have to talk to legislators about their legal obligations. How would you characterize the corporate culture of Facebook when it comes to the rule of law and the rule of obligations to the democratic jurisdictions that they work in?
I think your observations are exactly correct. In the lead up to passing of the California legislation, Facebook came out publicly in support of the California Consumer Privacy Act, but in fact was still behind the scenes lobbying against the law that passed. And we've seen this kind of time and time again. Currently, it's the first time I've seen in the US where the administration, Congress, and the companies are all aligned to pass federal privacy legislations. And primarily that's to essentially preempt the California law and potentially give them carve-outs from GDPR, because the kind of a conservative administration is feels like it might be oppressive to business, and Facebook is very involved in that process, is my understanding.
Thank you.
Thank you. Ian Lucas.
When the Cambridge Analytica scandal, GSR, first broke, in 2018, the big part of it, we had a lot of publicity out there saying how dreadful it was, and Mark Zuckerberg appearing before a couple of committees anyway with sackcloth and ashes, saying how dreadful it was. And ever since then, on our committee, we've been trying to get to the bottom of this data transference issue. And the conclusion I've come to is that actually the transfer of data is the modus operandi for Facebook. That's actually, far from them thinking it's wrong, it's actually what they do. Is that accurate?
I think that's right. So the platform, as you describe it, is simply designed as an API for third parties, advertisers and app developers, to reach consumers and collect information from consumers, right? And so that two-way transfer of serving content and collecting information is the business model of platform. It's essentially the platform. And the reason why it's beneficial to say a web platform is that when you visit a website with your web browser, those companies still, you guys have, you have a strong cookie law, you know how that works. You're in fact more privacy protective in a web browser because your web browser only reveals certain categories of information that you explicitly disclose to the site, or things like IP address or the web page you came from, which is required. On the Facebook platform, app developers receive a great deal more information, right? Such as your friend graph, your hometown, information that that Facebook chose to make public. So count one of the FTC consent, the FTC settlement, the complaint, was that Facebook, I believe it was count one, was that Facebook changed the rules in 2009. That information at that time, prior to those changes, information that was public only to Facebook. And that meant you needed to have a Facebook account to use the platform. They made those changes to make it public to any website, including platform apps, in order to, I believe, allow app developers to get more information and incentivize creation of apps on their platform.
So the exchange of information really within Facebook is not seen as wrong. It's what they do.
Absolutely. Yeah, and I think the wrong, I believe, I interpreted the statements about wrong where it went to the wrong actor, not that the transfer was wrong. right? I think and the issue is, as we know, it's essentially like inviting a friend to a party and they bring all their friends, right? And you're not necessarily monitoring the door and you inevitably have a terrible party. I think that's essentially what they meant as wrong.
Thank you.
Thank you. Clive Evans.
Yeah, I just wanted to clarify. You're saying that what Mr. Allen said to us in certain aspects was categorically wrong. Do you think he knew he was telling us the things that were incorrect?
So I think the issue is that it's a very nuanced technical issue. And so if you describe V1 of the API as something from, say, 2012, after the Facebook settlement, to 2014, and you exclude whitelisted apps and instant personalization, then his statements are generally true, right? But if you include all the carve-outs, and we know the carve-outs to be significant, right? We know the carve-outs with the whitelisted apps to be significant. We know the carve-outs to API access to be significant. Then it was deceitful, right? It was in fact misrepresenting what the platform can do. As recently as June of 2018, June of this year, using the BlackBerry token that the New York Times was testing with, that was provided to me, I was able to access user data in lieu of a user's platform settings, right? So that was as recently as this year, right? These problems existed, right? Again, the description there was it was either for a whitelisted partner or a soft landing, is I believe the term they wanted to use for the API transition. So there was all these caveats, right? And so the question is, do the exceptions swallow the rule? And I think it's false to make statements that categorically this information isn't available when in fact it is.
So, I mean, because he's a member of this Parliament. I mean, he's a member of the House of Lords, and it is quite a thing if he's come here knowingly misinformed this committee. I mean, are you saying it's possible that he might not have known what he was saying, or
right,
but should have done if he was coming in front of this committee?
Right, or it's possible that he was trying to generalize and not be specific of all the kind of edge cases and exceptions that are present on the platform, right?
Thank you.
Thank you. Nathan.
I just want to start, you mentioned Facebook will do the bare minimum. You know, we were in Washington in October of last year, and we asked Facebook as part of our study on commercial sector privacy legislation, and we were looking for recommendations, and we said, well, would you propose additional rules, and are you open to a new regulation? And they indicated the answer was no. And then today they're saying, oh, we're open to regulation and we want more regulation. We want you to regulate us, and wouldn't that be great? So it's funny how quickly the tune changes once their bottom line is threatened. I just want to be clear about specifically Ms. Stevens was asking questions to Mr. Allen, and her concern, as I understood it, was if I use an application, my friend's information is shared regardless of their privacy settings. And Mr. Allen said, no, that's not the case. They could go in and they could check a box that said right. And are you saying that there's confusion there, that was not the case?
There was also confusion there. So the whitelisted app story that the New York Times ran in June, the story about BlackBerry, in that case, those apps, for example, would have access to friends' information. I actually tweeted a screenshot.
Regardless of what anyone clicked.
Regardless of if you explicitly went to the platform settings and said, "Do not share my platform." And then additionally, in the testing for the findings of the FTC in 2012 and 2010 to 2012, FTC found that if you, for example, mark individual status updates as private, right, those status updates were shared with apps, right? Or if you mark individual profile elements as private, those were also shared with apps.
So the notices they were sending to Canadians, at least, and maybe others with respect to the Cambridge Analytica information, was that even private messages may have been shared. We didn't get any confirmation from Facebook Canada to the extent of that. Their notice was may have been, which was striking as well. So The FTC, you were there at the FTC and during the investigation of Facebook. And was there any indication at the time or any? So I'm less familiar with the FTC consent or the Facebook consent decree, but the extensive and unrestricted or fairly unrestricted, I would say, sharing of friend data with developers and app developers, was that part of the settlement in any way? Was that flagged for them at the time by the FTC? Was that a concern of the FTC?
So the complaint alleged misrepresentation of what what Facebook stated in their privacy policy, as well as what the platform privacy controls would do, right? That it wasn't specific to friends' information at that time. It was just all information, including friends' information. In 2014, or 2013 or 2014, Facebook, I think, with a blog post from Zuck himself, stated that your information will not be accessible to apps your friends install, and that was in 2014. They made a statement on their blog, and then they updated their privacy policy. But based on the New York Times reporting and based on my testing, that was still accessible to certain apps, at least the whitelisted apps that we tested.
Right. Okay. Thank you.
Thank you. Paul Farrelly.
Mr. Soltani, I wasn't expecting you to be here, so and you clearly weren't.
I wasn't
said you weren't
expecting
expecting that. So it's what I'm just curious about is what's prompted you to sit in front of all people here.
Just to be clear, that he's walked in freely off the street. We haven't
we haven't planned to
arrest him or anything like that.
What's prompted you to come and sit on your own in front of everyone here to give evidence about Facebook?
So I've been in.
What are your core concerns?
Yeah. So I've worked on. So I was also the primary researcher for the What They Know series, the Wall Street Journal privacy series. I worked on this issue for the last decade, highlighting kind of the contrast between statements the companies make and their actual practices. That was my graduate research was essentially this, highlighting these differences. And I've been working to help structure and pass privacy legislation to address this concern. And so when I was literally just listening to the hearing this morning, and it's the same thing I did for the congressional hearings in the US, when companies make technically nuanced and perhaps deceitful statements, it kind of gets under my skin. Right. So my role is primarily as a technologist, right? So a lot of what I do is try to understand technical issues and explain them to policymakers and journalists. And time again, I think companies can exploit these nuances in very technical, and this is an incredibly technically adept committee, but I think companies still are able to exploit nuances and understanding and make these statements. And with the exception of actual audit and investigation, there's very little that you all and the public can do to challenge these statements. And so that's basically why I came. So on these specific issues, I've actually physically tested them myself, or digitally tested them myself, and so I know them to be true.
When you use the word deceitful, then we've seen some documents. We've had much toing and froing between ourselves and Facebook, and from what we've seen, you could use the word intrusive to describe the company. You could use the word rapacious, amoral, sometimes cavalier, contemptuous. How would you best describe the culture at Facebook as you found it?
I think I think it's best encapsulated by Mr. Zuckerberg's first appearance in the U.S. Senate and then later the House. The Senate hearing where he testified most recently, it almost seemed like a game of tennis, right? Of like, you ask me a question and I'm going to answer you in a way that you can't challenge, and I'm going to win that volley. And that's essentially that contemptuousness, that ability to like feel like the company knows more than all of you and all of the policymakers. I think most recently, if you might have seen this announcement that Facebook's going to create a Supreme Court to deal with fake news. Like the level of confidence one must have to say that the statement was, I've studied this issue for 2 years and I feel now qualified to create a Supreme Court to deal with fake news issues. And on one hand, it speaks to the power of Facebook as a platform, and on the other hand, it speaks to the contempt that I think the company, at least the senior leadership of the company, has for an existing democratic process and multiple regulatory frameworks.
And do you think it's grown too big to care? It's so set in its ways. Why should it change? Because it's been phenomenally successful. And the answer, if not engaging in a tennis match, is simply to send in expensive lawyers.
Yeah, and I think they'll do, if there are laws mandated, right, I think they will comply with those laws. I think they have a lot of influence, both politically and economically, right? In the U.S., a lot of the reticence to pass strong policy has been about killing the golden goose, right? So it's a leading sector in the U.S. economy, and there's a lot of worry that regulation will hamper it, right? And I think that's somewhat short-sighted. For me, the policy debate is similar to the environmental policy debate of 50 years ago, where there was worry to kind of clamp down on companies for emissions and for environmental harms, and we found that actually by doing so, we incentivized a great deal of innovation in that space, innovation around solar energy, innovation around renewable fuels. I think the same is true in this industry. I think smart legislation will incentivize innovation in encryption, innovation in privacy protective technologies that allow us to use these services but not suffer harms, not just from the companies themselves, but also from breach and bad actors, right? I've been trying to promote this idea of, folks are familiar with usability testing is a common term in this space. Usability testing is to platforms employ usability testing to see how their platforms are used. I've been trying to promote this idea of abusability testing, right? Platforms invest resources into seeing how their platforms can be abused to harm consumers. And I think smart policy would incentivize that kind of investment, as we've seen that incentivizing in the last 10 years around cybersecurity.
Richard Allen, who came before us this morning, is a former MP. I've not met anyone who dislikes him. I like him. He's the likeable face of Facebook. His successor as the Member of Parliament for Sheffield Hallam, Nick Clegg, is just about to move to California. Was an MP and then became the Deputy Prime Minister. So they bought a former Deputy Prime Minister of the United Kingdom. So I just wonder what that says about Facebook.
In the US as well.
And all Nick Clegg.
Do you think it's, can you see whether it's changed, after all the recent scandals, whether it's really changed its ways? Any evidence?
I think there's some evidence that the company is investing in the area. It's not clear whether they're investing enough, and they're clearly investing on the lobbying and policy side. But I think it speaks to, I think a good data point, particularly around the fake news issue, is the kind of issues and stories surrounding Alex Stamos, the former CISO's departure, right? And to understand what the company culture with Ms. Sandberg and with Mr. Zuckerberg versus, say, the security team, right? And I think it's almost, it's problematic to treat it as a monolithic organization. So my understanding, for example, is that there are parts and stakeholders at the company, currently, presently, and former stakeholders that were very invested in these issues. And in fact, the only reason we know about the fake news issues and the tampering was because of the security and trust and safety teams that essentially, contrary to the senior leadership's will, publicized some hints of this very early on, right? And so I think there are people at the company that care about these issues, and there's some investment, but I think the fact that Alex Stamos just left or was kind of pushed out speaks to what their priorities are, and they currently don't have a chief information security officer.
Okay.
Right.
My final question is, I asked Richard Allen earlier on to what extent he believed that Facebook had complied with the FTC orders, and he said, to his knowledge, paraphrasing, fully. Is that Is that your view? But the FTC is now looking again.
Well, the question was whether
they complied with the orders given to them by the FTC.
Have they complied, or are they in violation of
either?
So my personal opinion is that they are in violation of the consent decree. Again, that's my personal opinion, and the FTC has publicly confirmed that they're investigating the company. Now, the thing to remember about U.S. regulatory regimes, particularly under privacy, is it's essentially the two hooks are unfair or deceptive, and unfairness is a difficult hurdle usually for privacy-related issues. So primarily comes down to whether the agency thinks the company made deceptive statements, right, that were in violation of the consent decree with regards to their practices. And I'm hopeful that around these whitelisted apps, around the oversight of apps, particularly the monitoring of API and the knowledge they had regarding what app tokens and app developers were accessing the API, I think that we'll find that that was negligent, or the agency will find that that was negligent. But again, it's purely that the company made statements that they were doing this, right? The more, essentially the US regime, the more a company says that they take privacy seriously and they take steps to protect privacy, the more the FTC has hooks. If a company says we do our best and we really don't do much, the FTC really doesn't have a lot of hooks with regards to going after them. It's a little bit different. It's a market, kind of a market policy solution.
So just in conclusion, the email evidence that we have and that's also lodged and sealed in the court may be highly relevant to FTC inquiries.
I think that would be critical, particularly if there's senior leadership that were aware of these issues and chose not to prioritize those issues. I think that would be very telling.
Thank you.
Thank you. Joe Stevens.
Go back to Richard Allen's evidence and my question to him this morning, because I was very specific in asking if I had set privacy controls, Facebook could override them, and I didn't know about that in terms of allowing access to my information through apps and friends, etc. So what I'm interested in is, from what you've said in your evidence just now, how long a period would that overriding have been happening? How far back and until how recently?
So
in the kind of worst case scenario.
Right. So the kind of the period. So there's multiple privacy controls on the platform. There's individual profile elements and status updates have individual privacy controls, and then you have a kind of global platform privacy control where you can turn off app access. So in the 2009 to 2012 period, I don't believe platform controls existed at that time point, and the per status update or per profile element privacy controls did not do anything for apps. So if you set a status update to private, an app that you installed would have access to that information, even if it was set to private. I believe subsequent to the FTC order, the company began adding platform controls, as well as making sure that if you set a profile status update to private, an app wouldn't have access to it. However, certain whitelisted apps and apps like instant personalization still had access to those in lieu of those settings, right? So, and that was after 2012. And then from the kind of testing that I did most recently in 2018, whitelisted apps, the apps we tested for were BlackBerry at the time, but I believe there's other apps that will be kind of highlighted, had access to consumers' information even if they had platform settings turned to off. And they had access to friends' information as well. So timeline-wise, 2014 is when Mr. Zuckerberg announced that apps would no longer have access to your friends' information, and there was a grace period of, I think, a year that they allowed that setting, and then they also gave certain apps even a small grace period, and then they allowed whitelisted apps to completely override that setting altogether, right?
So we're effectively talking about, in the case of whitelisted apps, potentially 9 years, nearly a decade, where they have been able to access
friends' information. That's
overriding
right.
the privacy
I believe
settings.
so, yes.
Right.
Yep.
So that effectively is not accidental, that is privacy violation by design, isn't it?
I think so, right? And the argument that I've heard the company make is that we're allowing app developers to develop apps for us that that we wouldn't otherwise make. So the statement I've heard is that we wouldn't build a BlackBerry app. We're not going to invest the resources. There's just not enough BlackBerry users. Sorry, Canada. So we're going to instead let the platform essentially have administrative access to user information like they were us, and thereby override user settings.
Okay, thank you. That's really helpful.
Brendan O'Hara.
Thank you, Chair. There's enormous frustration, I think, around this table at what we heard this morning. This is certainly for the UK's committee. It's our third attempt to speak to Facebook about this. What do you think, from your viewing of it this morning, what did Facebook want to get out of today?
I think, if I had to summarize, it seemed like hopefully appease you all and not have to call Mr. Zuckerberg to testify.
And do you think if you were Mr. Zuckerberg having tuned in, you'd be quite happy with what was achieved today?
I think so. I think they were the tone was, this is what we do, right? The statement about win-win-win. I think a lot of that, the undertone of that was that this is our business model, right? This is our essentially the exchange of personal information and the use of our platform by third parties is by design, and this is kind of how we make money. It's kind of, again, to the earlier question of how I would describe it, there was a question in the Senate hearings in the U.S. where Mr. Zuckerberg responded, "Senator, we sell ads." Some of you might remember this quote about how they make money, right? They're like, you give your product away for free, how do you make money? Zuckerberg responded, "Senator, we sell ads." I think the tone was similar, of like, you all need to understand that this platform is monetized by the exchange of personal information, and that's how the platform works, and that's how it's going to work, right? And I think that was the message, the undertone of Mr. Allen's comments today.
And therefore, any change to that model of how the business works will be fiercely resisted.
I mean, he also said that this morning, where he said, we will follow the rules as you pass them, if you pass new laws, but he raised his hands and said, but it's going to have, it's going to have consequences, right? And that was almost, I thought, and again, you might hurt the golden goose, right? There's a lot of money in this ecosystem. And so I think that was kind of a warning.
So would it be fair to say, do you think that Richard Allen was the right person for Facebook to have sent here?
I think so, yeah. I mean,
from their perspective.
Of course, you all know him. You all trust him, right?
I think you'll stick with the first statement.
Trusted him, right? I mean, if it were me, I'm not sure. So from my understanding of the company, if I were to invite one person, it would be Ms. Sandberg, right? My understanding for a lot of these decisions are hers, right? She is the one who makes the monetization calls, that makes the priorities, and that's who I would want to see kind of up here testifying on these business decisions, specifically on the monetizations and the decisions of what to prioritize.
It seems to me that over the months that we've been investigating and speaking directly to Facebook representatives, that everyone knows a bit. Most folk know enough to get by without ever being able to implicate the boss or their company. So is there an individual at Facebook who knows everything?
Right, probably not, right? One of the comments I made earlier regarding one of the reasons I don't believe the company is able to regulate itself is that for a lot of this period in 2010 to 2016, maybe 2015, the motto was move fast and break things, right? And so from the technical implementations that I saw regarding, for example, the whitelisted partners, the whitelisted apps, they were incredibly hacky, they were incredibly thrown together, very haphazardly, right? If it seemed as if a business development person and an engineer implemented a feature quickly. For example, in order to whitelist an app, all they did is say it was pre-installed for all users, right? That was the workaround instead of creating a new kind of oversight regime or a new API specifically for those apps. They essentially just added a flag to the database that said it's a pre-installed app, so it gets permissions by default. So it can kind of skip over the consent process. That's very hacky. That's very not straightforward, and I think that makes it very hard to regulate. It makes it hard internally to oversee, right? And I think as a result, there's engineers just kind of running in the direction set for them that the kind of leadership has set. And I'm not sure that leadership is giving guidance to say, no, you know what, this is a priority. User privacy is a priority, or data use is a priority.
So it's almost like an internal Wild West at Facebook.
I think up until 2015, 2016 it was, right? There's really early news stories about how interns they would do these hackathons, which are like these coding sprints, programming sprints that someone could come in and program for an extended length of time. And there was news stories about how an intern could come in for a summer hackathon, and make changes to the live platform. Right, and at that time, the platform was only hundreds of millions of users. It wasn't, billions of users. But to think about just a user without oversight, without change control, without kind of governance, to just make a change to a code that affects millions of people, right? I think that speaks to the culture that was present at the time. And I think that's probably changing, right, given all the pressure. But I think it's important to note that the roots of the company as the Wild Wild West.
So given that there representatives of 400 million people sitting around this table, where should we be looking for the unambiguous truth about what Facebook are doing and how they're doing it and how they plan to proceed in the future?
I mean, I think so at least in the UK, you guys are in Europe. I think you have audit rights. The DPAs can do audits of companies. And again, I've worked as a technologist who's for that period of time seen a great portion of the source code of the company and how the company operates. And even at that time, when it was a tenth of the complexity it is today, it's incredibly difficult to discern how the company is operating. But at least you have the ability to go in and challenge the company as you've done before. I think that the key is to have a compliance regime that has requirements of the company that is verified externally, right? So, one of the other recent news stories has been around the oversight regime that the company employs. It's employed by, they essentially, the FTC consent decree requires that the company hire auditors that they pay for, that then does privacy assessments that are self-attested, that then the company signs off on. And I think having kind of an auditor that you pay and that lives in-house with you and that you control is not a sufficient audit scheme. So having a DPA and having the company essentially make attestations and demonstrate to the DPAs that they are in compliance to whatever regime you set, I think is perhaps something you might consider. And that's what we do with utilities over time, right? That's what we do with any large institution, right? We have safety, so airlines, right? We have safety standards that they have to meet, and then they have to demonstrate with an outside auditor.
Yes, thank you.
Thank you. Charlie Angus.
I really thank you for this, and I'm maybe going off form here in a committee, but I think I'll ask my question to the chair.
Okay.
As a guest. I've been a member of Parliament for 15 years. I've been in all manner of committee hearings. I've seen positive, I've seen negative, I've seen reluctant. I have never been in a set of hearings where getting basic answers from people who know better has been so difficult.
Tom, this is Dex. I did dial in the IB. They said 4650. I did hear something, so now I'm standing here, and does anyone up there in New York need to talk to me? Yes, I do. I hear you. Test 1, 2, 3. All right. Thank you. All right. Thank you, Tom. Just wanted to make sure. It gets so crowded. It's already crowded here. I won't be able to come up in front. One balance, everyone.
Although it is played. Yeah. Okay, the boys. Yeah. Thumbs up, everyone. We good? I correct you by putting right angles going this way and this way. But they added this in the new camera. Put it up. Well, I have a lot of questions that are unanswered. But it still doesn't make it stable. Right. Oh, hell no. Oh, hell no. Hey, I'm proud of the fact that he's from the South. We have our RoboCam ready for Jim. I studied at San Francisco School for Megaphone Mal. Okay, just want to make sure we're good. On top of the hour. Well, you have to coach football. It does help. I know. It'll be late, it'll be short. Like the rest of the day. Yeah, well, we'll work it out. Yeah. Do it. Hold on, I'll make sure. I'll do it. Tell me what you want to do. I'll make sure. Do it together. You can hold him up against the wall. So he doesn't fall. Perfect. Oh yeah. Perfectamundo. $20. She said 15.
1, 2.
Thanks very much.
I missed my wife last.
I've always wanted to ask why they have the White House in Washington as opposed to the White House Denver. I'm
The White House Nantucket is.
Nantucket, yeah.
Well, there is a White House in Moscow.
Don't go there.
The White House could dance too.
Yeah. White House, Bardstown, Kentucky.